MSW Media.
Welcome to Teacher Quit Talk. I'm Miss Redacted.
And I'm Mrs. Frazzled. Every week we explore the teacher exodus to find out what, if anything, could get these educators back in the classroom.
We've all had our moments where we thought, what the hell am I doing here? From burnout to bureaucracy to soul-sucking stressors and creative dead ends.
From recognizing when it was time to go to navigating feelings of guilt and regret afterwards, we're here to cut out the gaslighting and get real about what it means to leave teaching.
We've got insights from former teachers from all over the country who have seen it all. So get ready to be disturbed. Join us on Teacher Quit Talk to laugh through the pain of the U.S. education system. We'll see you there.
The rule of law is not just some lawyer's turn of phrase. It is the very foundation of our democracy. The essence of the rule of law is that like cases are treated alike. That there not be one rule for Democrats and another for Republicans, one rule for the powerful, another for the powerless, one rule for the rich and another for the poor, or different rules depending upon one's race or ethnicity. To serve as Attorney General at this critical time is a calling I am honored and eager to answer.
So yeah, now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hello, everyone. Welcome to Clean Up on Aisle 45. It's Wednesday, May 25th. This is episode number 71. I'm your co-host, Allison Gill, and with me, as always, is Andrew Torrez.
Woo, thank you. How are you doing today?
I'm doing okay. I had a kind of a relaxing weekend. I got a little sick yesterday, but it's not COVID. It might be allergies. I just feel kind of a little under the weather, but I'm getting better. So I guess everything's okay.
Well, take it easy. And, we've got a upcoming 3-day weekend, which means absolutely nothing for you and I, but but still relax, and hopefully our listeners are having a nice low-key week in anticipation of that extra holiday coming on Monday. And special thanks, shout out to our new patrons, Adra Pansa, Matthew Vernon, hey, welcome aboard here, Tanya Dawn Graham, our friends over at the Fallacious Trump podcast, give them a listen. And I became a patron to give a shout out to Kelly. Hi, Kelly. Hi, Kelly.
Hi, Kelly. And remember that you too can get a shout out by heading over to patreon.com/aisle45pod and pledging as little as $1 an episode. It's AISLE45POD. You get the ad-free version of the show. You also get our bonuses like the fantastic Zoom hangout we did last Friday, the 13th of May, and we try to do those monthly-ish, so I look forward to that.
We're doing our best, but patrons are wonderful. They make the show go, and we love you all, but we love our patrons more, so there you go.
Just pulling no punches. Speaking of not pulling any punches, but also some bad late-breaking news that maybe we should talk about at the end, or we could talk about at the beginning, but we're going to go over a couple of court filings with you. The first one is an 11-page opinion on the RNC case. Remember when the RNC sued the January 6th committee to stop them from getting documents and stuff from their vendor called Salesforce? Because Salesforce was like, this is bad. We feel like we actually might have sent some messages out that stoked some violence on January 6th. And we're all set to send stuff over to the committee, and the RNC, Republican National Committee, sued to stop it, and we have an update in that. That's a filing. And then we have a sprawling 40-page crazy pants filing from Eastman's attorneys in the Eastman email case being heard by Judge Carter. Judge Carter is the judge who said there were crimes committed here, and that's why they handed over emails to the 1-6 committee. One of those emails fell under the crime fraud exception of attorney-client privilege of work product doctrine. So we have 601 more emails, and apparently Eastman, who was granted 40 pages, used all 40.
Oh, yes, he did.
For to tell us why he's innocent and why why Judge Carter should change his mind on stuff he's already ruled on and why he shouldn't allow any of these other emails to go over to the committee. It's a really interesting filing. I look forward to talking to you about that. But let's talk about the RNC.
Okay, let's start here, and should we start with the good news, right? Which is that this is a completely ridiculous lawsuit without merit. And as a result, the U.S. District Court for the District of Columbia, again, this is Judge Timothy J. Kelly, somebody in front of whom I have practiced. And when it was assigned to Judge Kelly, who, was a Trump appointee, we talked about on this show. I said, look, would Judge Kelly and I agree as a matter of politics on there? Maybe not. But I've practiced in front of him. I have found him to be open-minded and fair and smart. And I had absolutely no doubts that he would have no problems adjudicating this case. And put a pin in that, but spoiler alert, I was right, at least at this level.
Yeah, we'll get to that really cool appellate court
we
news
shall.
in a second. But the court gives a great summary here of what has happened. So I'm just going to directly read this summary, and it'll bring everyone up to speed, although I think everyone's probably already up to speed. But the ruling here says that the U.S. House of Representatives Select Committee issued a subpoena to Salesforce.com, Inc., a third-party digital vendor for the RNC, Republican National Committee, demanding it produce to the Select Committee some of the RNC's confidential information relating to emails and other communications sent around the time of the November 2020 presidential election and January 2021 certification of the Electoral College vote. The RNC then sued Speaker of the House Nancy Pelosi, the Select Committee, and each member of the Select Committee, also known as the House Defendants, to challenge the subpoena. The RNC later amended its complaint to add Salesforce as a defendant, and the RNC challenged the subpoena on 6 grounds, asking for injunctive relief, arguing that, first of all, the subpoena violated the First Amendment, that it, number 2, violates the Fourth Amendment, number 3, it does not advance a valid legislative purpose, number 4, they say the committee lacks the necessary congressional authorization to issue a subpoena, okay. Number 5, the subpoena is excessively broad and unduly burdensome. Tiny violin. And number 6, it violates the Stored Communications Act. Now, the court dismissed the RNC's claims against the House defendants because of their immunity from suit under the Constitution's speech or debate clause. And they found that the RNC had standing to press its claims against only Salesforce, dismissed as moot the RNC's Stored Communications Act claim against Salesforce,
Right.
assumed in the RNC's favor 2 potential non-jurisdictional hurdles to the merits of the RNC's other claims against Salesforce, and entered judgment against the RNC on those claims. The court also temporarily enjoined all the defendants from acting on the subpoena until, as relevant here, right, with the little temporary injunctive relief here, while the court resolved a motion for injunction pending appeal filed by the RNC before May 5th, 2022. Yep.
Yeah, that is all exactly correct. And remember, the game here is not the merits. The game is a court going to grant an injunction that requires Salesforce not to comply with the subpoena, right? Because in the absence of that ruling by the court, Salesforce has said, yes, we will happily comply with the illegal subpoena issued by the House 1-6 committee and turn over all these documents that the RNC definitely does not want the 1-6 committee to see. Now, what's in those documents? I don't know. But if the Republican Party does not want the 1-6 committee to see them, I would very much like to see them. That's my standard for review here. So remember, when we're talking about injunctive relief, right, there are basically 3 kinds of inquiries here, right? The first is there irreparable harm to the parties, right? And here the court says, yeah, there is going to be irreparable harm to the RNC in the sense that if they do not issue an injunction, right, all irreparable harm means is, so what it means for harm to be reparable is capable of being recompensed with money, right? So if we fuck this up in some way, you know, we can fix it later on. Right. And most cases are like that. Right. And so the court will be like, you know what? There's no need on a breach of contract suit, for example, if they say preliminarily, like, we're going to listen to this. Like, at the end of the day, we can require party B to give party A if you're suing over $100,000, let's say, right? We'll just issue an order for the $100,000, and we'll issue prejudgment interest, right, dating back from the moment you filed this complaint. So we can make you whole on lots and lots of injuries that are associated with money. But on something that's not associated with money, that's what we call irreparable harm, right? And that's, when we broke this down, when we discussed the dismissal of the 1-6 committee as a defendant, we said, look, there probably is irreparable harm to the RNC here, in the sense that once those emails are turned out, you can't unturn them over, right?
Right.
Yeah. Like, Liz Cheney's seen them. Like, that's it. That's done.
Right. And I think the court finds that here, that they could suffer irreparable harm. But there are other factors to consider in the legal standard, which the court spells out here. Number one is, are you likely to succeed on the merits?
And that's the other. So, as a lawyer, when you're working through, and different courts number these in different ways, but as a lawyer, when you're working through, am I likely to get an injunction for my client? Or, this happens to me on both sides of this, is my client likely to, suffer having an injunction imposed on it by the court? You work through the questions in this order, right? The first thing you ask yourself is there irreparable harm, right? Like, that's why we did it. But that's, as you point out, that's not enough. That gets you over the first hurdle. Then you ask the second question, which is the party seeking the injunction, have they demonstrated the likelihood of success on the merits, right? And different jurisdictions handle this in different ways, right? Like, that the more serious the potential harm is, there's sometimes a sliding scale, right, that says, hey, don't make us show that we're 95% likely to win because the harm to us would be devastating. You should only make us show that we're 60% likely to win. And sometimes courts entertain that argument. But in any event, right, it is still this kind of weird exercise that you go through in which the court says, I know we're not going to look at the merits of this claim yet. I know we haven't gone through discovery, but I need you to give me your best argument right now why you're going to win, right? And think about that. Like, that's a weird thing to do in front of a court when, they don't have all the rest of the background. Here, the RNC has demonstrated that it has a serious legal question, right? So, and by serious, that means not frivolous. That's way, 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 way shy of, and we're likely to win, largely because the answer to, are you likely to win on the merits, is no, not at all.
Right.
And yeah, go ahead.
But if you can prove irreparable harm, and there is a serious legal question, but there's also a very huge public interest, whether the balance of equities tips in their favor becomes a consideration.
And that's like the third level inquiry, right? So this is also the balance of the equities test is present in kind of your ordinary situations, right? Well, I've talked about like how I represented a client that had a swimming pool, and the landlord tried to lock her out of the swimming pool and, interfered with access to the equipment. And we had to go to court and get an injunction that says, hey, landlord, stay away, don't lock the premises, stay away from the swimming pool, don't touch the stuff, don't interfere with her business, right? And there was a little bit of like, balance this third prong, right? Balance of harm, which side do the public equities favor, right? And we were able to say the public equity tips in favor of a business that serves the public. It was almost exactly a year ago this time, right? It was Memorial Day weekend, and families think about taking their kids to the pool on Memorial Day weekend, right? But that really, in most cases, tends not to be dispositive when you're talking about private interests, right? Like, they're going to be important public policy concerns on both sides, right? Like, it's also, the court would say that there is an important public policy concern in making sure that landlords get paid or whatever, right? Like, so, you know, it's not a huge balance one way or the other. But when you're involving the government here, that there is this kind of carve out that says, if you present a serious legal question, but not one that rises to the level of likelihood of success on the merits, and you would suffer irreparable harm, and the rest of the public policy efforts tip strongly or tip sharply, as the leading DC case says, in favor of one party, then you can issue an injunction, right? And the issue there is, if this is a case that it really is unsettled, there is a need for, quote, more deliberate investigation, we're not going to hold one party to the side of saying, hey, we are absolutely likely to win or more likely than not to win, because if the law is unsettled, well, you might not be able to demonstrate that, right? And nevertheless, it might fit within this kind of specific public policy niche. That's the position that the RNC was arguing.
Yeah. And the court says here, they sum up by saying, you know, the court assumes the RNC has shown that its appeal presents a serious legal question. And without a doubt, the court says the RNC has shown it will suffer one sort of irreparable harm absent an injunction pending appeal, but it has not shown that the merged balance of equities and public interest factors, quote unquote, tip sharply in its favor. Thus, the court will deny the RNC's motion only insofar as it requests an injunction pending appeal. And then they say, even so, the court will grant the RNC's request for a brief administrative injunction, so you can seek injunction pending appeal from the circuit. And they break it down like this. They say, first of all, on the claims matter, given the court just resolved the case against the RNC, the court does not find that the RNC is likely to succeed on any of its claims. And then they say, yes, the court assumes here the RNC's First Amendment claim presents a serious legal question. And further, the claim is a complicated one, right? Having to take up a large portion of the court's merits analysis and requiring extensive unpacking of the legal framework as well as application of that framework to the facts. And the court thus assumes the claim presents a fair ground for litigation and warrants more deliberative investigation. But the question then is whether the other three factors tip sharply in the RNC's favor, and the RNC argues, absent an injunction pending appeal, it will suffer irreparable harm and that the case will become moot before the circuit can decide on the merits, meaning they'll get the stuff. The 1/6 committee will get the stuff. It'll become moot. And the court agrees. The RNC also argues that the merged balance of equities and public interest prongs weigh in its favor. In considering these merged factors, the court must balance the competing claims of injury and the effect an injunction would have on each party, while paying particular regard for the public consequences in employing the extraordinary remedy of injunction. And on the RNC side of the scale is the harm that, absent an injunction, it will suffer, the de facto deprivation of the basic right to appeal. On the House defendant's side of the scale is the added delay. Will that further interfere with the Select Committee's investigation, which is at a critical juncture, etc.? Already strong public interest is heightened for the Select Committee's urgent and weighty investigation, and moreover, the judge continues, the court is ill-equipped to weigh any potential reduction of House defendants' harm that might come from expediting the resolution of the RNC's appeal, because the timing of that appeal is beyond the court's control. The circuit, therefore, is better positioned to weigh any potential mitigation along these lines that may redound to the benefit of the RNC in the balancing of equities and the public interest.
Yeah, so let's break that down, right? Essentially, what Judge Kelly is saying here is, look, I am giving you the full benefit of the doubt here, RNC, that if I do not issue an injunction, you can't put the genie back in the bottle, and that there is a serious question on the merits of whether I should issue the injunction. But weighing against that is the public policy need for the 1/6 committee to complete its investigation and for you not to be able to run out the clock, which is your entire game strategy and has been since 2017, right? So it is, I think, really, really significant. This is the page 10 of the opinion, if you go to it, in which the court says the court must weigh the select committee's need to conclude its investigation at a critical juncture as it approaches public hearings and is attempting to complete its investigative efforts heavily. Quote, even under ordinary circumstances, there is a strong public interest in Congress carrying out its lawful investigations, requiring courts to take care to not unnecessarily halt the functions of a coordinate branch of government, right? This already strong public interest is heightened for the Select Committee's urgent and weighty investigation. And that was sort of the preliminary lead up to. So remember, in order to win on this theory with a likelihood of success on the merits as low as just, well, this is a serious question, the RNC has to show that the public's interest is strongly favored, that all the factors point in favor of not complying with the subpoena. And Judge Kelly is very reasonably pointing out, like, under the best case scenario, like, yeah, you have a good argument, but the Select Committee has a good argument too, right? Like, it needs to be able to finish this up and not just have you, tie it up in the courts indefinitely. And, if there are strong interests on both sides, then this factor doesn't tip one way or the other.
Yep. And that's what the judge says. With weighty considerations on both sides of the scale, the court cannot say that the merged balance of equities and public interest factors tip sharply in the RNC's favor. And for all those reasons, we deny the motion to the extent it requests an injunction pending appeal. So that he's kicking this to the circuit court.
Yep.
Right? Which I was all fine and good with until
me too.
Dum, we get the judge pull, right? The judge draw in the circuit court. Everyone knows that the appellate court has a 3-panel judge. They're randomly assigned, seemingly, and guess who they pulled?
Yeah, why don't you share that with us? Because this is bad.
All right. Well, looking at my photo here of the order, it looks like we have Judge Rao, Judge Walker, and who's the third guy? Katsas?
Judge Gregory Katsas. Yeah. And again, so Judge Katsas is also, so this is 3 for 3 on Trump appointees, right?
Wow.
Yeah. So that's some bad luck, right?
Yeah, I don't think you could have pulled a worse.
You could not, right? So there's 16 judges on the DC circuit. To get 3 Trump appointees is pretty bad. Judge Katsas is the best of the 3, right? He's competent and qualified to serve on the DC circuit. Naomi Rao, you have heard of. She is a pro-Trump hack and an idiot. Or like, I cannot tell if she is, right? Like, if she's an idiot in the mold of, Ted Cruz and, Ron DeSantis, right? Like the Ted Cruz, again, year ahead of me at Harvard Law School. Ron DeSantis, very, very well educated at Ivy League schools. They pretend to be morons to cater to their constituents. And Naomi Rao has been nothing but a pro-Trump hack since being on the bench. You might recall her as having authored the opinion that said, I don't see how you can enforce a subpoena. So, that's a real bad draw. And then the capper, the one that folks, other than those who listen to this show, might be scratching their head about, is Judge Justin Walker, declared virtually uniformly not qualified to sit on the federal bench at all, right? Like, literally, this is somebody who was teaching writing and debating idiots like me, right? Like, seriously, I engaged in a debate sponsored by the American Constitution Society and Federalist Society against Justin Walker. He was thoroughly dishonest. You can go hear that over on Opening Arguments. He went from, like, not even teaching substantive law school subjects, right? Like, he was teaching writing classes, like not con law, like not cutting edge stuff, to appointment to the federal bench, to several months later appointment to the DC circuit, right? So he went from the Eastern District of Kentucky to the DC circuit in record timing. Typically, by the way, you're supposed to have 12 years of experience on the federal bench before you get elevated up to a circuit judge position. 3 months, not quite the same. Prior to that, right, he was, again, the ABA, bipartisan, declared him not qualified to sit on the federal bench because he had not so much as taken a deposition, filed a motion for summary judgment, let alone tried a case. So, just exists as a pro-Trump hack, buys lock, stock, and barrel. I call him out on this in the middle of our debate, tried to perpetuate the Amy Coney Barrett. This was before Amy Coney Barrett was elevated to the Supreme Court, but in her previous investiture, during the Senate Judiciary Committee hearings, the extreme religious right was circulating how unfair it was to question her about the fact that she's a member of a religious cult and is programmed from birth to be against Roe versus Wade. He tried to go on an idiotic pity party story during our debate of how that violates the Constitution's religious test. And if you want to hear me call him out on that, go head on over to opening argument. But I take no pride in destroying this guy in a debate because, he's on the DC circuit now and I'm not. So this is really, really bad. Yeah.
And it'll probably be overturned 2-1.
It'll be 2-1. Yeah.
And then my question for you, does that then go en banc? Can the committee ask for an en banc review?
It not only can the committee ask for one, the DC circuit can declare, take a vote by a majority sua sponte en banc. And just like the last time Naomi Rao tried to pull a fast one and say, hey, I'm going to rule that subpoenas can't be enforced, never minding the, Latin definition of the word, the DC circuit stepped in and smacked that down. They're going to do the same thing here. But the problem is, they're running out the clock, right?
Right.
So we'll see what happens. The court absolutely is going to grant. So as you point out, Judge Kelly, and again, this is 100% proper, granted a brief interlocutory injunction to allow the RNC to appeal. You do that so that you don't deprive somebody of their substantive rights by, the procedural delay in filing your appeal. And there is no doubt that the DC Circuit is going to stay the enforcement of that judgment pending the appeal. How they conspire with the RNC to delay this case as much as possible will be the interesting thing worth watching, because make no mistake, Naomi Rao and Justin Walker are not judges. I don't give a shit what it says after their name on Wikipedia. I don't care that they were confirmed by a partisan Senate. They are hacks who exist to do what Trump wants on the bench. And they don't deserve our respect of being called federal judges. They have repeatedly demonstrated time and time again that they've fallen below and beneath that minimum standard of justice. And we should look at this as being hijacked by the Trump wing of the Republican Party. And there's nothing that is inappropriate procedurally to try and get around that. And there's nothing that they won't do to try and further the big lie. Justin Walker probably fucking believes the big lie. He is that far gone. Naomi Rao probably believes it. That they are, if they showed up on Ginny Thomas's email list, I would not be surprised, right? These are true believing. Again, they're too smart to play as dumb as they do to the public. And it's bewildering to me to watch federal judges do this. This is, runs contrary to the entire Federalist Papers. I'm sorry, I'll stop. I'm angry, but there we go.
Yeah. So we'll follow this and keep everybody posted, obviously. We're going to be back. We're going to talk about the Eastman filing, the 40-page glorious Eastman filing. But we do have to take a quick break, so everybody stick around. We'll be right back.
Hi, I'm Frances Callier.
And I'm Angela V. Shelton.
And we're Frangela. You know what you need in your life? The Final Word Podcast.
Yes, you do.
That's right. It is the final word on all things political and pop cultural.
Where we make real news real funny.
Where we inspire you so you can #resist.
Subscribe and get a new episode of the Final Word Podcast each week. It's the news we think you need to hear.
That's right. We think you need to hear it. Okay?
Yeah, it's what we say so.
That's right. And because all we do is give, every Thursday you can listen to our hysterical podcast, Idiot of the Week.
We round up the stupid because you know what? Somebody has to.
Okay. All we do is give.
They Might Be Giants have been on the road for too long. Too long. And They Might Be Giants aren't even sorry. Not even sorry. And audiences like the shows too much. Too much. And now They Might Be Giants are playing their breakthrough album, Flood. All of it. And they still have time for other songs. They're fooling around. Who can stop They Might Be Giants and their liberal rock agenda? Who? No one. This ad was paid for with somebody else's money.
All right, welcome back to Clean Up on Aisle 45, and boy, oh boy, they gave Eastman 40 pages, and he took them all and ran with it with a bunch of crazy pants stuff. Used all 40 pages. His lawyer begins here by taking the first however many pages to say there's actually amazing amounts of election fraud. And so we can't be criminals because we truly believe the election was stolen. We truly believed it.
So do you want the fun part first, or do you want to just continue with my high level of anger from the last segment? You pick.
Let's go with the fun part. Let's pivot to fun.
Okay. So one of the things that you might not have noticed, because if you're just seeing the documents when they sort of hit the public domain, as opposed to me, who, obsessively lives on Pacer, hitting refresh for this case, which is 22-99 Central District of Columbia. Yeah, I've typed that an awful lot over the years, over this past year. This brief was the subject of so we talked about the time schedule, right? And Eastman missed the deadline, because of course he did. Yeah. Filed a motion for extension that says plaintiff's brief was due at 5 p.m. today Pacific time. Due to an unforeseen family situation that arose during final drafting and editing, undersigned counsel was abruptly unavailable for a time. The brief should be complete later tonight, so we request a brief extension of time as a matter of hours to file our brief. Of course, the court was always going to grant that. It's just hilarious to me that, John Eastman manages to find the biggest, like, my dog ate my homework time and time again. And hysterically, that's not the only other docket entry. As it turns out, that motion for extension of time failed to comply with the court's electronic filing requirements. It did not attach the document as an exhibit for which you were seeking a motion of an extension of time, which, sure, again, neither of those are going to affect in any way the substantive outcome. It's not like the court is going to say, nope, sorry, we're not going to read your 40-page brief because you filed it 3 hours late. But it is, the amateur hour is, would be comical, and this is my pivot to angry Andrew for the rest of the episode, were it not for the fact that John Eastman's counsel is lying in this brief. They are engaged in sanctionable behavior, and I'm specifically calling out Charles Burnham, senior partner, founder at Burnham and Gorokov in Washington, D.C., whom John Eastman hired for this. And Charles Burnham, as far as I can tell, really, really good white-collar criminal defense lawyer. You may read into that whatever you want for why John Eastman would hire a white-collar criminal defense lawyer in connection with an effort to fight a subpoena. I know my view on that, but it helps explain why, as we've talked about over the course of this litigation, Charles Burnham has done inexplicably stupid things that no lawyer that would do these kinds of cases would actually do. So, for example, In response to a motion to compel, he filed a long statement of disputed facts. Well, you don't I don't know how to explain this. A statement of disputed facts is a thing you file in connection with a summary judgment motion, right? Like it is, because summary judgment says we agree on the facts, and as a matter of law, we ask for the court to rule in this particular way. And so when you're resisting summary judgment, you would say, actually, we don't agree on some really important facts. That's why this has to go to trial. That's when you file that document. Saying we disagree on the facts on a case that has not been adjudicated on the merits is, it's like somebody has been, auditing a couple of, they're like, I'm not a lawyer, but like Matlock was on in the bar last night. Like the sound wasn't on, but I think I got the gist of it. Like it is just mind-bogglingly wrong. And, so I'm sorry, I'm monologuing, so I'll let you come back.
No, I think it's hilarious. Some other things. Here, let me just give you some of the highlights.
Oh, please.
Of the argument that they're not guilty of anything. Here's a quote. More importantly, for present purposes, the mounting evidence about the scope of illegality and fraud in the 2020 election, the mounting evidence about fraud in the 2020 election undercuts any claim that the statements on the score made by Dr. Eastman and his client were made corruptly or dishonestly because of all of the mounting evidence. Okay. He says that even though Eastman himself says his legal theory was illegal and wouldn't get past any court, that no, we really truly believe the election. Look at all the mounting evidence of fraud. There's zero. There is zero evidence of fraud.
Okay, so I have to jump back in here because as evidence for this mounting evidence, the first thing that Charles Burnham cites is Trump versus Raffensperger, number 2020 CV 343255, Georgia Court, Fulton County, and are quoting from a verified complaint. Now, remember, a complaint is what you allege as the plaintiff, right? There is nothing to stop me from filing a complaint that says Allison Gill shows up in my bedroom every night and licks my ear, and it's weird, right? Like, no, I want to be clear. You do not do this, okay? But I can write that in a complaint. There's nothing to stop me from saying that, right? And that's what we discovered in every single one of these election law complaints, these that we've lumped together. Now Raffensperger, Trump v. Raffensperger in Fulton County was not represented by Sidney Powell, but falls under the category of Kraken law suits, right? Like these are suits challenging the election on various disputed grounds with absolutely unsubstantiated claims that have been debunked time and time again, and for which individuals and lawyers have been sanctioned. Trump v. Raffensperger was voluntarily withdrawn by the Trump team itself, okay? So you can't go citing your allegations in your, quote, verified complaint. And by the way, verified just means some asshole signed it, right? Like,
oh, yeah, but not only does he continue to do that, in several of these lawsuits, but he also says, it's almost like he's saying, and Judge, you should well know, this is Judge Carter.
Yeah.
Okay, this is the one who said there were crimes beyond a preponderance of the evidence. And this lawyer now, Burnham, is saying, and this court should know from its own in-camera review, there's ample evidence in those communications of illegality, fraud, and statistical anomalies in the election results that lend significant support to the statements made by Dr. Eastman and his client. Like, that's almost like any smart judge could see the fraud. It's like, holy shit. And then he goes on to say, in the prior round of briefing, Dr. Eastman raised numerous objections to the false statements of fact contained in the select committee's brief and submitted a separate statement of disputed issues of fact. The objections were not ruled upon, and the court, in many instances, simply accepted as true the select committee's assertions, based in many instances on unsupported newspaper articles and hearsay of hotly disputed facts, as if these lawsuits are not that,
So, point number one, this section cites as evidence a complaint that was voluntarily withdrawn by the plaintiffs, right? Like that is as zero an evidence as you get, right? That is at one point in time, but not now. I once told a court X, but I am not willing to defend that in court anymore, right?
But it proves my case here.
But now, I can cite that as evidence in an additional case. No, you fucking can't. And if I were the 1-6 committee's lawyers, I would 100%, I'm not being facetious about this, I would move for sanctions in connection with this brief. It is absolutely 100% sanctionable. It is reprehensible. It is horrific behavior. And Charles Barnum, I've said it here. I've said it on opening arguments. I've said it on a Twitter feed. Like, you are welcome. Bring on the defamation lawsuit if you think I'm mischaracterizing this in any way, because you will get your ass handed to you. Ooh. And I'll enjoy it. Okay.
Ooh, throw down.
This is sanctionable, unconscionable conduct that he knows is wrong. He cites to Dinesh D'Souza's movie.
Yeah.
The convicted felon Dinesh D'Souza's insane movie 2,000 Mules, which, by the way, is a completely contradictory system of alleging fraud. Like 2,000 Mules is talking about how there was ballot harvesting and whatever. 2,000 Mules is entirely different than the dead people were voting, which I fucking swear to God, that is in page 5. Quote, the complaint also documents a deceased voter's registration was changed from deceased to active 8 days after he passed away. Tip of the iceberg evidence that suggests a more widespread scheme of fraud. None of this, everybody citing these kinds of allegations has been sanctioned by any court in which they have not been voluntarily withdrawn. To recite them here is unconscionable.
I was going to say this just reminds me of the Michigan case.
Yeah.
That sanctioned Powell et al. Another thing here, this statement just stood out to me. At every turn, Dr. Eastman's efforts were designed to protect democracy by ensuring that illegality and fraud did not alter the results of the election, and that the full and transparent investigations into the serious anomalies would be had even if the outcome of those investigations simply confirmed the initial certifications.
Oh, yeah, right. This is the Ted Cruz line of which Eastman, we have every reason to believe, coached Ted Cruz to say this, right? So on January 6th, when Ted Cruz went to the floor of the Senate to ask for the relief that John Eastman put in writing, right? Hey, let's just pause this for a while and check on state certifications. And Ted Cruz said, even if there wasn't fraud, millions of Americans believe there was. And so letting this play out will at least assuage their doubts. And the only reason millions of Americans believe there's fraud is because people like you and John Eastman have been lying to them. Unbelievable. But I want to add, and I am grateful to Dr. Lawrence Lessig, right, Larry Lessig, who came on my show and made this distinction. It's a really, really narrow distinction, but it is crucial to understanding part of Eastman's overall lying process, and that is his constant, deliberate conflation. That's why I want to call him out here, between illegal and fraudulent, right? So you just read that in that sentence, right? Illegality and fraud, illegality and fraud, illegality and fraud. Those two things are very, very, very different, right? So in other words, a ballot can be illegal without being fraudulent.
Right.
A counting system could, let's take a look right now at, say, the Pennsylvania primary, right? The Pennsylvania Republican primary, which is too close to call, between David Montgomery and, quote, Dr. Oz, right? Right now, what that is going to turn on has to do with an application of Pennsylvania law that says you have to date your absentee ballot when you send it in. And again, because Dr. Oz has been on the conspiracy theory end of this. They're both terrible candidates, but Dr. Oz is also a snake oil salesman and huckster. So Oz, because he is the most closely aligned with Trump, probably is going to receive the fewest number of mail-in ballots because, his voters think mail-in ballots mean that you've sold your soul to the devil and have taken on the mark of the beast and whatever the fuck, right? Because he's Looney Tunes. He is arguing that you should rigorously apply the Pennsylvania law that says if an absentee ballot isn't dated, you throw it out. Montgomery's side has taken the opposite position, right? They're like, come on, if it has a technical defect that doesn't have anything to do with the underlying administration of justice, you have to count it, right? Like somebody made an honest but stupid mistake in filling out a government form. Should we try and give voice to them in a democracy, or should we say, fuck you, you've got to comply with the law? So let's take that to its extreme. Suppose, this is going to be heard by the Pennsylvania courts. It's going to go up to the Pennsylvania Supreme Court. Suppose the Pennsylvania Supreme Court says, yeah, you know what? Count the absentee ballots that are improperly or undated, right? Then Oz's team can say illegal ballots made and then suppose that provides the margin. Montgomery comes from behind and overtakes Oz and is the Republican nominee for Senate. Oz could say illegal ballots gave my opponent the win. He would be technically correct, but that has nothing to do with fraud, right? They're illegal on the basis of,
technicality.
Yeah. And part of, and so I appreciate your indulgence on that, because part of what Eastman has been saying from the very beginning is to lump abso-fucking-lutely everything into the category of illegal and then say, well, illegal is the same as fraudulent. And as we know from, the Michigan misquoting of an 1876 Supreme Court, fraud vitiates everything, so therefore we throw out the whole election. And none of that is true. Literally none of that is how any of this works. And the worst part is Eastman knows this.
So that's why he's connecting illegality with fraud.
Yeah, that's exactly
It's a reflexive control gig.
Yep.
Another thing here, because you were talking about 2,000 mules, right?
Another
thing here was it would require book-length treatment to address all of the factual misrepresentations that have been pushed by the Select Committee. Indeed, several books, such as Molly Hemingway's Rigged, have already begun to plow that ground, sampling
Molly Z. fucking Hemingway
to make the point.
Who publishes The Federalist, who is the editor-in-chief, or I don't know, fucking whatever. But and let me be clear about this. That is not the official publication of the Federalist Society. The Federalist is a toxic right-wing garbage pit that has published openly racist, right? Has published birther conspiracy shit about Kamala Harris, right? Who, by the way, was born in Oakland, right? It is, a more wretched hive of scum and villainy you shall not find, right? It is the unmitigated gall to cite to Molly Z. fucking Hemingway in your brief should be in and of itself sanctionable. Sorry.
No, it's fine, because the whole argument here, and this is literally what Eastman's lawyer is saying. Hey, why are you listening to the House of Representatives and the Attorney General and the Department of Homeland Security, Cybersecurity, and voting experts and secretaries of state? You should be listening to ridiculously awful lawsuits filed by now sanctioned lawyers. And Molly Hemingway's book Rigged, and convicted felon Dinesh D'Souza's movie. That's where the real information is. And how could you possibly and the way that he talks to the court in this is fuck. He's like, you should know by what you saw in those emails of all of the anomalies and illegality and fraud. He says countless examples of election illegality and fraud and expert opinion indicating a high likelihood of fraud were available to Trump and Eastman at the time. So was the fucking Bill Barr saying there was no fraud. So was the Department of Homeland Security up and down, the whole department saying there was no fraud. So was Rudy Giuliani was even like, we don't have machines that do this. Everyone. But you found 3 guys and a couple of crackpot lawyers. And so that is countless examples of illegality and fraud. Again, putting those two things together. And that's when he starts to cite the cases. Trump v. Raffensperger. then he talks about that specifically for quite a long time, right? He says, that's a good example. The thorough 64-page verified complaint. Okay, that's what he calls Trump v. Raffensperger. 4 supported by sworn eyewitnesses and expert affidavits, which we all know what happened with those affidavits.
We know what those expert affidavits are. Those quote expert, right? Spider and Terpsichore and like these expert affidavits were so false on their face that it led to lawyers being sanctioned in Michigan. Yeah.
Yeah, and then he goes on to say affected as much as 500,000 votes in Georgia.
Yeah.
Other examples of election illegality and potential fraud that were known at the time and subsequently confirmed abound, he says. State legislators, too, weighed in, highlighting significant illegalities and irregularities in their elections. And then he argues the committee relies on crazy bullshit like statements from the DHS and Bill Barr and the Attorney General and, people like that. And this is hilarious. Eastman wants to correct the record on a January 6th committee claim. He says, finally, we should correct the record on the Select Committee's claim that Dr. Eastman has acknowledged there was no support for his legal positions about the unconstitutionality of the Electoral Count Act's provisions, intruding on whatever powers the vice president has directly from the Constitution, and that he would lose any case brought by the Supreme Court 9-0. Remember when he said that? And he said that what he was doing was illegal and you should just break the law one more time? Well, we want to correct the record. As seems to be a common tactic of the Select Committee, Eastman's acknowledgement is taken out of context. It referred to the suggestion that had been made by others. I don't think. He's actually trying to say, I don't think this is illegal. Other people were telling me that it was. But not, Dinesh D'Souza or Molly Hemingway or anybody in the affidavits.
This lie is worth unpacking here. And,
yes.
and we telegraphed this when we talked about the initial hearing on the crime fraud exception. It is just... It's stupid to repeat this because you already lost trying to litigate this issue. But here's the game plan, right? John Eastman is trying to pretend that his pivot, we talked about this, right? This is the pivot, right? That his pivot from Vice President Pence should just go in, declare the electoral votes invalid, and announce that Donald Trump is president, right? That's what he was pitching on January 3rd, 4th, and 5th. Eventually, right, Pence's senior counsel said that's where they had the this position is unbelievably fucking stupid, and if you brought it to the Supreme Court, you'd lose 9-0, right? And then he said, well, maybe we'd get Thomas. And then they walked through that, and then he said, okay, well, Eastman conceded that no, they wouldn't even get Thomas, right? And they pivoted to, right, that what Pence should do is go in and request or demand or declare that he was going to pause for 10 days or 15 days or whatever to allow insurrectionists to bring additional charges.
And that was the email where he said, hey, you already violated the Electoral Count Act by not taking it back to the host.
Yeah.
You already violated by debating for more than 2 hours on Arizona. So why don't you just violate it one more little tiny time and delay the count for 10 days? That's that email.
And again, go back and listen to that episode of Cleanup on aisle 45. That Allison is not being sarcastic here in any way. The email says, what's one more violation of the law now that the Electoral Count Act is not so sacrosanct?
I know. I tend to paraphrase, but literally he said that.
It's literally what it says. And so it is the acknowledgement that this request is illegal, notwithstanding the fact that his counsel has now lied and said Eastman doesn't believe it. But more importantly, any attempt to draw a distinction here on the basis of the pivot is without a basis in law, because the part that would get rejected 9-0 by the Supreme Court is not the magnitude of Pence's actions, right? Be it declaring Trump president or declaring an I don't know, right? Like both of those have the same predicate action, which is Pence declaring shit. Right. And that's the thing that they worked through, that Eastman conceded. OK, you're right. the vice president doesn't have the power to declare shit under either the 12th Amendment or the Electoral Count Act. How do we know this? Because if they did, then there never would have been another election again in this country after the first one, right? Like every sitting vice president would just declare the electoral votes in favor of their particular party.
Right.
And there's no answer to this by John Eastman. Every time he's called under the carpet for this, he says, like, yeah, no, I agree. Like Al Gore couldn't have declared himself president in 2000. Well, if Al Gore couldn't have declared himself president in 2000, then you're admitting everything you're arguing now is nonsense, is without legal justification. Sorry.
Yeah, I know. And he is now trying to say, the Burnham here, Burnham and Eastman are trying to say, you're taking us out of context when you say that. I was just saying what other people thought, not what I thought. And that is complete and total utter. That's for fabrication.
And remember, and again, this illustrates the challenge that the 1-6 committee has in front of it. Okay. And it illustrates the challenge of holding Trump accountable for 1-6, right? Which I have said all along, like, my best hope for Trump in an orange jumpsuit is coming from Fani Willis and Fulton County, Georgia, because that is a specific narrow crime that I think they can prove. Mm-hmm. It's very difficult to prove that Trump didn't believe this bullshit, right? And especially to prove it beyond a reasonable doubt. And I think on the basis of what we know right now, and this is, is there a possibility that there's a smoking gun document somewhere? Sure, because we've seen the stupid ass emails that John Eastman writes when he thinks no one's looking. Okay, so there's possible that there's an email from John Eastman, to a state legislator copying Donald Trump that's like, hey, the president and I agree this is all a load of bullshit, but like you're ready to help us out anyway, right? Like ordinarily you wouldn't put that in writing. Wouldn't put it past John Eastman because he's put dumber stuff in writing, right?
Well, we might actually have that, right? Because let me roll.
I do. Okay, yeah, please.
Let me roll through these 11 arguments, and then if we want to talk about the individual ones, we'll break them down. But these are the 11 fucking batshit arguments.
And let me say, the way in which you can evaluate the strength of these arguments is that the nonsense we just discussed constitutes the first 18 of the 40 pages to which John Eastman was allotted.
Yes.
Right? So in other words, he spent half his brief perjuring. Charles Burnham spent half of John Eastman's brief perjuring himself, lying about cases, misrepresenting basic facts about the election that there is zero chance that this court is going to entertain. And more importantly, remember that this court is not a criminal court, sitting to convict John Eastman of 18 U.S.C. 1001 or of conspiracy to, seditious conspiracy or anything like that. This is a civil court looking, is it more likely than not, right? 50.1% that this was criminal behavior, a finding the court has already made. So with that in mind, go through the 11 arguments, please.
Argument 1, Trump was my client back then too. Mm-hmm. That's argument 1. Okay.
Yep.
Still doesn't cover crimes. Argument 2. Several of the emails are privileged because Eastman was emailing agents or other lawyers who had Donald as a client. Again, that doesn't cover emails in furtherance of a crime. Also, correct me if I'm wrong, Andrew, but just because someone's a lawyer doesn't make attorney-client privilege apply.
This is the same Donald Trump, like, yeah, man, if I just get a lawyer in the room, I can crime all the crime I want. And no, you must be seeking valid legal advice from said lawyer. And if you aren't, then, no privilege attaches.
And under this argument, because, he's mailing agents or other lawyers of Trump, he says 21 of the documents identified above are attachments to the email communications. Most are legal analysis memos and their supporting data. 21 are drafts of pleadings. 22 quintessential privileged material. I'm reading.
That's footnote
those
22 there. Yeah.
Never mind. Most are legal analysis memos and their supporting data or drafts of pleadings, which are quintessential privileged material, as well as work product. 2 include handwritten notes from former President Trump about information that he thought might be useful for the anticipated litigation.
Yeah. That's footnote 23, which is documents 23555 and 25905. And yeah, if you ask on the short list of Eastman documents I'd like to read, those are very, very high on my list.
Argument 3. Among the 601 documents in dispute, Eastman has also asserted attorney-client privilege over 50 documents where the client, or quote-unquote potential client, was other than former President Trump or his campaign committee. Argument 4. Among the 600...
And can I just jump in here? This is, again, whether deliberate or just incompetence, this is mangling the standards for attorney-client privilege and attorney work product privilege, right? Attorney work product privilege are the documents that you prepare in anticipation of litigation. All of these are communications with this subset of 50 documents were potential clients seeking Dr. Eastman's legal advice regarding the constitutional authority of state legislators to deal with election illegality and fraud, by going to the parking lot of a Denny's and pretending that they were the legitimate electors in their state. So, number one, crime fraud would still apply.
Yeah.
And I want to say there is, put a pin in that for a second, because I want to talk about an actual fair exception that Eastman could have but does not assert in this pleadings, which gives you some indication of the underlying criminality here that's being openly discussed. But the rest of this, right? This is communications with state legislatures, party committeemen, a citizen coordinating information for state legislators. If what you are doing is coordinating state legislative action, that is not attorney work product. That is not in anticipation of litigation. That is an entirely different function. When I advise members of Congress on particular aspects of the law or on things that I think Congress should take a look at, that's not privileged. That's something that you can subpoena and I would have to turn over. Yeah.
No, it's not. And potential clients aren't clients either. That stuck out to me pretty boldly, because it's like, well, just because, you might have to defend these guys when they get arrested doesn't mean all the crimes you discussed with them are legal or protected.
Let me put both of those back together, right? Because I said I want to talk about an argument that would otherwise have been available to Eastman. If somebody calls me up tomorrow, right, on my firm telephone line and says, hey, Andrew, I just killed a guy and I want to know, is it legal for me to hide the body, right? That client, that call 100% is privileged, right? Yeah. Even though it, number one, is not a client and not somebody I'm going to take on as a client because I'm not a criminal lawyer. And number two, he's ostensibly potentially asking for my help in a criminal enterprise, right? Because one of the things we want to protect is for people to ask their lawyers, hey, is it legal for me to do X? And for the lawyer to say, no, it is definitely not legal for you to do X. Don't fucking do X. This is an important part of my practice, right?
Right.
And so I just want to illustrate. Right. I just want to illustrate, like, that's where the real bar is, right? So yes, some privilege attaches to potential clients who call you up and go, hey man, I did it. I killed somebody. Will you be my lawyer? And I would say no. And then, that the cops can't call me to the stand to say, well, isn't it true that,
Yeah, but this would be you reaching out to a potential criminal and saying, hey, would you hide a body?
See, this is what I love about doing this show with you, because you have, A, you understand the legal aspect, and B, you've cut through the bullshit. That's exactly right. Attorney-client privilege, in particular, prospective attorney-client privilege, exists for the benefit of the client, not for the benefit, or prospective client, not for the benefit of the lawyer, and not to allow you to tiptoe up to the line of, how much crime can we plan before the nodding and the winking? And, I've got to get like extra Visine for my fucking eyes because of all the winking. Like, no. All right.
Yeah. No, I gotcha.
Sorry, I did a rant mid argument, and we're
totally
never going to
fine.
get through these all.
It's totally fine. I'm just going to list them, and then if there's something you want to talk about. Argument 4 among the documents is there are 3 in which Eastman was seeking legal representation for himself in a potential case asserting breach of contract in violation of constitutional rights. Okay.
Don't know how to evaluate that, right? But possible, plausible. I don't know.
Yeah. Okay. I wonder what he's talking about there. I'd like to know. Argument 5, the court's prior ruling that Eastman's use of his Chapman email account did not waive privileges controlling. I don't know what that means. Okay.
Yeah, so what they're saying is that, remember when the court ruled, and I think it's fair to say that the court ruled that there is an attorney-client relationship between Eastman and Donald Trump, notwithstanding the non-existence of any documentation that would go to prove that, right? Like the court said, hey, we're going to assume arguendo based on the conduct of the parties that Donald Trump actually engaged John Eastman as the lawyer.
Yeah, and even though you use the Chapman server, you do have an expectation of privacy in communications that are protected by attorney-client privilege.
That's right. And but I would distinguish between those two holdings, right? Like I would say, if I'm the 1-6 committee, I think it is settled as a matter of law that in connection with 1-6 that Eastman represented Trump and that there was an attorney-client relationship. Whether that makes things privileged, obviously, you've argued for the crime fraud exception. I do not read that ruling as foreclosing on the 1-6 committee from going back to, if there are efforts to recruit like 90 different, quote, potential clients to say like, hey, this is something that we would still want Chapman University to weigh in on, right? Like, because remember, we heard testimony from Chapman University that basically had to skirt the line a little bit, right? It was like, hey, we like our law professors to do things that are of public interest, but we don't want them to endorse a particular candidate. So that's why, the 2000 stuff that Eastman did was fine, but this 2020 stuff was not fine. And, when you and I looked at that and we're like, that's a hairline distinction, right?
Yeah.
Eastman is now saying, oh, look, you said Chapman University, it's fine. Their university email policy does not apply at all. I have complete expectation of privacy over that. And I don't read the court's prior ruling that expansively. I don't think it's going to matter here, but I just want to flag that.
Yeah, no, agreed. Argument 6, I actually had a question about. Argument 6 is Eastman says 557 of these 601 documents are covered by work product privilege because we were talking about any number of different lawsuits, including Trump v. Raffensperger, Trump v. Bookvar, Texas v. Pennsylvania et al., Trump et al. V. Biden et al., and Trump v. Wisconsin Elections Board, and Trump v. Kemp et al. So all these, he's saying most of these are work product privilege because I was talking about anyone advising on any number of these different lawsuits, this litigation. And my question was, if the litigation itself is illegal, if the litigation itself was in furtherance of a crime, for example, Texas v. Pennsylvania et al., is it covered by work product? It is litigation. It is technically litigation, but it's, I just wonder where that crime fraud exception weighs in there, So there's a bunch of different things here. So number one, in the same way that fraud vitiates everything, right? Like the crime fraud exception vitiates everything. When you prepare attorney work product in connection with committing a crime in connection with a case, the fact that you've done so in connection with a case does not render that privileged, right? Like you can't, again, previous example, you're about to call my client to the stand and put on the murder weapon, and so we plan an Ocean's 11 style heist to get the murder weapon out of the evidence locker the night before.
That's not attorney work product. My job, an attorney's job, is not to help my clients commit crimes. So yes. But secondly, and I think more importantly, attorney work product is in some sense a very narrow kind of exception, right? Let me give you a perfect example of this, right? Like, let's think about like the O.J. Simpson trial, right? And O.J. Simpson had the dream team and Alan Dershowitz and everybody else. And so all of the communications, if there was a subpoena in connection with that case for all of the communications between O.J. and his lawyers regarding how to manage the press at the end of every day, okay, which undoubtedly there were, and probably this did come up in the civil suit. Right? I don't know. I didn't follow it that closely. Those are not privileged communications. They're not they're not attorney work product because, again, attorney work product must be actual legal stuff you have done in connection with the case or with an anticipated case. So I suspect, again, I don't know, but as I look at these descriptions and they say, for example, that 380 documents were related to those particular cases, I imagine a lot of them are documents of the form, right? Are communications with state legislators of the form, hey, we have this lawsuit pending in Trump v. Buchvar. It's not going great for us. And so if we lose, would you be willing to declare yourself a Trump elector and petition the state legislature to overturn the results on the basis of differing slates of electors? That's not work product, even though it mentions the lawsuit. Right. So,
right. Because now it's just, if you have a lawyer in the room or if you mention a lawsuit, you've got privilege.
Yeah, that's again, I love the way you cut through my excessive verbosity. It's not work product because it touches on a lawsuit. It must be a legitimate attorney thing that you do in connection with an anticipated or an actual lawsuit to count as work product. We don't know because we're not looking at these documents, but this feels heavily like wading through a field of bullshit right here. Again, we don't know. Maybe every single one of these are, sample pleadings in these cases that Eastman emailed around. And if they are, the court will say that, right? And if they are, and I want to be clear on this because look, I want Eastman to have to give up all these documents. I want there to be a subsequent criminal referral, and I want Eastman in an orange jumpsuit as much as anybody. But I am a lawyer, right? Like, and if these are legitimate privileged documents, I don't want to create a standard that says lawyers should have to turn over privileged. Of course not.
No, of course not. All right. And that's argument 7 brings up what you're another, you just gave an example of, if they're talking to state legislatures. He wants to argue that state legislative proceedings should be considered litigation when you're talking about work product privilege. They say work product protection should apply to legislative proceedings that are adjudicatory in nature. And Eastman asked the court to, rethink your previous decision. Because my communications with state legislators are subject to work product privilege, and the congressional electoral count and state electoral count selections are adjudicative proceedings, and documents prepared for them were in preparation for anticipated litigation.
So let me again do my best devil's advocate for this argument, and it's kind of ironic in light of the Fifth Circuit's ruling that just came out with respect to the SEC that held that these adjudicative proceedings do not count as court proceedings. But here, real example. The EPA issues a demand letter to you, Allison, and says, hey, your factory is emitting, chloromethyethylene at 2 parts per million, and the rules require it to be no more than 1 part per million. So we're going to have a hearing, and if you were found to be in excess of the rules, you're going to have to install new filters, reduce the output, and
where
also
you're going.
remediate.
I know where you're going because if I am prepping with my lawyer for that hearing, that's in preparation.
That's in preparation
but
even though
hearings,
it's not a lawsuit, right? So,
but that's not what this was. As you know, these were people plotting to throw out electors, not have legitimate sort of hearings to decide. I mean, it's a good argument. It's the only one that you'd be able to make, right? Like, yeah. We had it in the Denny's parking lot, and
right, and that's the point. Is that yes, there are administrative proceedings before government agencies, right? Executive branch agencies, both state and federal, that look a lot like a trial, and to which attorney-client privilege ought to attach. But that doesn't mean that it attaches to everything the executive branch does, or in this case, the legislature does, right? And we know this because there are a great many executive branch administrative adjudicatory proceedings in which you don't have the right to have a lawyer there at all, right? And so, like for example, if you're redistricted, right? If you are moved into another voting district by the state, you just get informed of that by a letter, right? Like, you're not entitled to a hearing. You're not entitled to go petition that. You're not entitled to a lawyer. The court doesn't have to appoint one for you, right? Like, that's just nothing attaches to that. And so the idea that attorney-client privilege would attach to anything, no, this argument proves way too much. But I wanted to say, there's a kernel that's not insane, right?
Right.
But
right.
Yeah, but this argument is not good.
Argument 8: communications with dual role attorneys or advisors do not lose work product protection.
Almost true, right? like it's true. So in other words, we've talked about this before. I do this all the time, right? Like, I serve as legal counsel for my clients, and when they are conducting a business deal, sometimes I also help them with the business negotiations, right? Like, oh, hey, they want to buy X asset from you for $1 million. You should really push back. I feel confident that they're going to go to $1.5 million, right? Like, and the important part, and so I am serving in a dual role in that capacity. I'm advising them on the legal aspects of the deal, but also on the business aspects of the negotiation. And it is true that the fact that I am in a dual role does not mean that everything they say to Torrez is now discoverable, right? That would be a terrible rule. But it does mean that this is the important part. The stuff I do that's not law stuff is discoverable, right? So if I put in an email and I'm like, hey, these guys are fucking morons, and you can definitely ask for $2 million, and they say, we want all your negotiation docs, they've got to turn over my document saying these guys are fucking morons. Because you know what? My saying they're fucking morons is not a legal adjudication. It's not legal advice. It's business advice. So yeah. Communications with somebody just because they're in a dual role does not lose the work product protection over legitimate work product.
Yep. And now we get into argument 9, which is where Eastman says the fact that a client has not yet been determined does not undermine work product. Sure, but in this case, he's talking about a group of statisticians working with him conducting a statistical analysis of the Georgia Senate runoff election in anticipation of election litigation that never materialized.
You doing your fucking Mike Lindell impersonation is not being a lawyer. It just isn't.
No. Argument 10, one he already lost. That the subpoena is unconstitutional because it violates the First Amendment. He's just going to throw that in there again.
And again, 4 pages of that, right? Like,
yeah.
I just want to point out that, like, the last couple arguments, like 7, 8, 9, were all a page, so 8 went on for a while, but like, a bunch of these are knocked out in like 3/4 of a page, but no, First Amendment. Everybody who's made this argument related to Trump, which is the primary one they've trotted out, has lost like a champion, right? Like, lost like a Mike Tyson opponent in the 80s. It just beaten down brutally and swiftly in 35 seconds. And we got 4 pages of it here. So,
but argument 11 is my favorite. And this one basically says, hey, we couldn't have obstructed an official proceeding because 1 out of 11 judges agrees that it wasn't an official proceeding. It says the court's crime fraud finding doesn't apply to these new emails. Then they then decide to argue that the court's crime fraud finding was wrong, saying, hey, one judge, Judge Nichols, who's reconsidering, by the way.
Right.
Obstructing an official proceeding doesn't apply here, and you have no proof of deceitful and dishonest means to say that we violated 18 U.S. Code Section 371, right, to defraud the United States. We didn't commit any crimes. And by the way, these emails don't apply to the old crimes. You got to have brand new, fresh crimes.
You're welcome to make the argument, and again, I just want to point out, as we keep pointing out, deceitful or dishonest means for purposes of 18 U.S.C. 371 require this court to find on the preponderance of the evidence, more likely than not, that it was deceit, craft, trickery, or at least means that are dishonest. So in other words, if you think the guy that said, hey, man, well, now, the Electoral Count Act is not so sacrosanct. What about a little more criming? If you think it is at least more likely than not that dude was dishonest, that's the basis for having the requisite proof of intent. And again, fact finders do this all the time. They are called upon to evaluate testimony and go, yeah, we're not, it seems like on the basis of everything that you probably weren't being honest with us in that testimony. And this court has made up its mind about John Eastman's veracity.
Yeah. So those are the arguments. I can't remember the expedited briefing schedule, but I think within the next couple of days, we're supposed to get the House committee's response. I think they have 20 pages to respond.
They have 60
60
pages.
pages to respond.
And that is due tomorrow as of you're listening to this. It's
and then the
Thursday.
reply is 20 pages.
And the reply is due on the 31st. That is 20 pages. I cannot wait for the 1-6 committee's response brief. If they don't file for sanctions, I am going to do my very best. I don't have great lines of connection to the 1-6 committee, but I'm going to do my very best to get to them that this is they should be looking at this and reserve their right at minimum to move for sanctions for the unbelievably dishonest nature of this pleading.
Yeah, agreed. We're gonna have to push comings and goings again because we got so many leads on these filings.
I was mad.
It's totally fine. We have so few. They're it's getting fewer and fewer as time goes on and on. So I think we can reserve them for monthly. So we're gonna do that next time. But thank you very much, Andrew, for answering all my questions and laughing along with me, because that was just one of the that brief just blew my mind, honestly.
Yours and mine both. It was just something to behold. So thank you for giving me an outlet.
You're welcome. And as always, we'll be back next week. And look, keep an eye out on your emails. We're probably going to set up another one of our cool Zoom calls for patrons here pretty soon, coming up in probably second week of June or so. I might be in DC. I might be in DC when we do that. So that would be cool.
Love it.
All right, everybody, until next week. I've been Allison Gill. Thank you so much.
And I'm Andrew Torrez, and this is Clean Up on Aisle 45.
Clean Up on Aisle 45 is written, researched, and produced by Allison Gill and Andrew Torrez, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Clean Up on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com.
Hi, I'm Harry Littman, host of Talking Feds, a roundtable that brings together prominent figures from government law and journalism for a dynamic discussion of the most important topics of the day. Each Monday, I'm joined by a slate of Feds favorites and new voices to break down the headlines and give the insider's view of what's going on in Washington and beyond. Plus sidebars explaining important legal concepts read by your favorite celebrities. Find Talking Feds wherever you get your podcasts.